It's a crime of choice, deciding to get behind the wheel and drive after you've had too much to drink.
Nearly 60,000 people charged with DWI went to court last year in North Carolina. About 1 in every 5 of those cases were dismissed.
And we found it happened more in one local county than in anywhere else in North Carolina.
We're one part of the formula. Our part is to look for those people who are impaired, build a case, and then try that case, and then hopefully we'll get a verdict guilty.
Most DWI defendants who went to court in North Carolina last year did wind up with guilty verdicts. Some defendants are found not guilty, but many more cases are dismissed, not by judges, but by prosecutors. According to court records, prosecutors in Columbus County voluntarily dismissed a higher percentage of cases last year than any other county in North Carolina.
I think your news organization deserves a lot of credit for alerting me to some statistics that at that point I was unaware of.
When I first asked District Attorney John David about the dismissal rate, he said he'd get to the bottom of it. Poring over the court documents, I found several reasons for dismissing cases. The arresting trooper or officer doesn't show up in court. Blood tests are not back yet from the SBI lab. Those are common in many counties, but in Columbus County, other cases stuck out.
And one of the things that was revealed in my analysis of Columbus County was that we had a person in place who was not doing his level best.
These are just some of the dismissal forms we got in our public records request in Columbus County. The prosecutors are supposed to sign the backs of these forms, and if you go through, you see many different prosecutors' names, but one we see more often than others is the name Kyle Melvin.
We had a prosecutor who was substituting his judgment for that of the court. He was concluding that someone was likely to be found not guilty, and as a consequence, he was saving some time and saying, let me dismiss it now. Well, the far better approach is to put that in the courtroom and let justice be done in the public square. A 56-year-old man with 4 previous DWI convictions had his case dismissed last September after 7 continuances in court. Part of the reason given by the prosecutor, the officer requested dismissal, and I was on board, based on the lack of evidence impairment. Yet records show this defendant blew a .15 on a roadside test after being stopped for doing 76 in a 55 on Highway 74 near Whiteville. Another 56-year-old driver, also with 4 prior DWI convictions, had a case dismissed last July. Records show a sheriff's deputy found this man driving an ATV down the center of Highway 76 around 4 o'clock in the morning. The deputy noted a strong odor of alcohol and said the man was unsteady on his feet. This case was dismissed for no field sobriety test other than the portable breath test. The defendant refused breath analysis, no evidence of impairment. And records show a 29-year-old female had a blood alcohol concentration of .19, nearly 2.5 times the legal limit when she was involved in a crash on Old Dock Road last December. The reason given for dismissing her case? Exemplary non-commissioned officer in U.S. Army, perfect driving record, high classification security clearance. Defendant completed 20 hours of substance abuse. With some of the dismissals I saw, I looked at them and I said, you know, we can do better. I was disappointed. I knew that someone wasn't doing their job as good as they could have.
Not long after our original call to John David, his office confirmed that Assistant DA Kyle Melvin was asked to resign or be fired. According to this email, Melvin chose to resign.
You know, as a leader, I accepted responsibility.
David says he's met with all chiefs of police in Columbus County, the higher-ups in the sheriff's office and the highway patrol, and with the staff in his office about ways to do better.
There's always frustration, you know, the fact that you say, well, I went out and I done it, and now it ends up this way. But I have to encourage my guys to keep a positive attitude, because once they go out, they gather this evidence, they take it to the courts. It's up to the judicial system to say whether someone's guilty or not guilty.
I wanted them to know that I accept some measure of responsibility for what occurred here, and that I'm committed to looking back at some of these cases, refiling some where appropriate, and putting the right policies and personnel moving forward to fix this situation.
Now, John David told me that a state grant allowed his office to have DWI court where selected prosecutors would handle all of the DWI cases. That grant, though, ran out in 2012, and the DWI cases then went back into the district court mix for other prosecutors to handle. That grant also provided mandatory training for local law enforcement to help officers be better at building DWI cases for the prosecutors. John David says he plans to reinstitute that training as part of his improvement plan moving forward. Now, we did reach out to Kyle Melvin through a family member asking for a comment or to share his side of what happened. We have not received a response from him.